Hello and welcome to the next module. In this module we're talking about the most important and the most interesting question, and that is who gets the money. And that is really what we're all about. We're creating these structures, putting stuff in them, the stuff in question, assets which have value. What are we doing it for, why, and who's actually going to end up getting those things. That is what this module is about. Put another way, we're talking today about beneficiaries. So if you go back to our second module, we looked at the basic structure of a trust. To recap very, very briefly, we have the founder, the person who creates the trust. We have the trustees, the people who manage the trust, and we have the beneficiaries, and the beneficiaries we will talk about today. The founder, he puts his house or his money or his assets into the trust. They are now no longer his. It's quite important because the trust protects against somebody trying to attack him or her. The trust doesn't have legal personality, so it's managed by the trustees, in this case Fred and Susie. And Fred and Susie, if you look at the land register, or you look at the bank account, or you look at the company's office, you will see that the owner, according to law, is Fred and Susie, but as trustees of the XYZ trust. So they are the owners according to law, but not really the owners because they are there as owners only in the capacity of managers of the trust. And who is the real owner? The real owner, who does it really belong to, is the beneficiaries. And that sounds really great. But what people do not understand, and what we're going to talk about today, is that if you are a beneficiary of a trust, that house is not yours. It might be yours one day, or part of it might be yours. Or if it's a discretionary trust, you might get nothing at all. But whatever the outcome is, today, now, it is not yours. You have an interest in it. You have a legal interest. We talk about beneficial interest. And you have, forget about legal vocabulary, you have an interest because you're probably very interested, but it's not yours yet. Okay, let's look at different kinds of trusts, different kinds of beneficiaries. So in the last module, we talked about fixed trust. And here we have a fixed trust, and we have fixed beneficiaries, and we have Doris. And Doris is entitled to a third of the money in the trust when she reaches the age of 25. But at the moment, she's 17. So at the moment, she's not entitled to anything. But when she gets to 25, then absolutely she will be. So there is some fixed knowledge, some fixed right. She has nothing now, but she has quite a certain certainty that if she gets to 25, because if she dies, then the situation will be different. But if she gets to 25, then she'll get that money. That's great. Okay? But remember, she doesn't have it yet. It's not hers. That's a fixed beneficiary. Then we have a discretionary beneficiary, as we saw last time. And maybe the plan is the same. Maybe there is Doris, and she has the idea, the plan is that she will get a third of this when she's 25. But with a discretionary trust, it's even clearer because that's not written anywhere. It's not written anywhere in the official documents that she gets the money when she's 25. It doesn't say when. It doesn't say how much. And what we actually potentially have is a whole bunch of other people around the place who can also potentially get that money. With a discretionary trust, I'm going to move myself like this. Look at that, isn't that amazing? So I'm not in the way. With a discretionary trust, you typically will see named beneficiaries. So maybe it will say the beneficiaries of the trust are Doris and a whole bunch of people. More often, you will see beneficiaries defined by groups. So it will say, for example, my children. Now, my children is a much better definition than Doris and Pamela and Susan, because my children is great. It includes also future children. And they, when they're born, they automatically become beneficiaries because they're automatically part of the group. But whether you're named or whether you're in a group of beneficiaries, it really doesn't make any difference, because you are a beneficiary, and that gives you an interest. It gives you nothing, no ownership yet, but it gives you an interest, a legal interest, and maybe a personal interest in this pile of money. But be very careful as well, because what you very, very often will see is a possible beneficiary, potential beneficiary, sometimes called an eligible person. There are many different words. And somebody who is a possible beneficiary is not a beneficiary. They are somebody who can become a beneficiary if the trustees decide to make them a beneficiary. Okay, this is a bit of legal finesse here, but it's quite an important distinction. And if you are a beneficiary, it's very useful for you to find out what kind of beneficiary are you. Are you actually a beneficiary, or are you a possible beneficiary? So again, if we look at our example, it could be different people have different models for this. It could be that the three children, my three actual children, are beneficiaries, either because I named them or because they belong to the group of my children who are the beneficiaries. And all these other people, cousins, nephews, nieces, and whoever else, grandparents, uncles, aunts, whoever else it may be, they are possibly not beneficiaries, at least not beneficiaries now, but they can become beneficiaries if the trustees decide to make them beneficiaries. Why this difference? It's going to have an impact on what rights the people have. And what you will find is that in some countries, there are no actual beneficiaries. Everybody is just a possible beneficiary. Okay, we're going to go through and talk about some of the rights and so on. But as a general comment, I can tell you now that if you are a possible beneficiary, then you have most likely no rights to anything, no rights to any information, no rights at all. And if people don't want to give you rights, then that is the way that they're going to go. If you are an actual beneficiary, in other words, a named beneficiary or a group member, then you do have some rights. I have to say that this is an example of this course is designed to talk about trusts everywhere in the world, and I'm going to do that. I'm going to generalize and tell you about beneficiary rights everywhere in the world. But this is an area in which the actual situation varies very much depending on the legal system of the country in which you are. So this is more like a general comment. If you are a beneficiary of a trust and you want to know more, then ask what is the situation in your particular country. Let's talk about typical rights, though. Okay. By the way, that's why I put question marks everywhere, because I'm not telling you this is the law. I'm saying this is a question that you probably should ask. Right? So the first right that I would say you probably have as a beneficiary is the right to know that the trust exists. And that seems obvious, but actually if you think about it, it's not always so obvious, because you can imagine situations where a founder wants to protect his children from themselves. He doesn't want them to know that they have a big inheritance or a big a future gift coming. And so sometimes a founder might want to set up a trust and actually not tell the beneficiaries, and there could be good reasons for that. He doesn't want them to change their behavior. And there are a few countries in the world where it is possible to do it that way, but to be honest, most places, pretty much nearly everywhere, if you are a beneficiary of a trust, then you must be told that the trust exists. Remember though, if you are a possible beneficiary, then probably not. Okay, so if you're a beneficiary, you will know. If you are not a beneficiary, then you won't know. I remember many years ago, when I was a young lawyer, we had a rule that said that we, or the client, did not have to tell the client, or the trustees did not have to tell the beneficiaries that the trust existed. But if the beneficiaries asked questions, then the trustees had to answer the questions. So if people were clever, they could probably guess that there might be a trust, and then they could go and ask the trustees, can you tell me if there's a trust? And the trustees had to say, yes, there is. But those days are gone, and as I say, in most countries, if you are a beneficiary, you'll probably know. If you know, then you probably also have the right to either request from the trustees or automatically receive lots of information. So, for example, the accounts of the trust, some reports. You may have the ability to go to the office of the trustees and say, I want to look at all the documents, please. And that's typical that you would have those rights. I would say most often they are reactive, so nobody's going to send you anything. But if you ask, you have quite a lot of rights. Again, if you are a beneficiary, if you are a possible beneficiary, then sorry, nothing. Okay. Likewise, you can expect that you have the right to have your questions answered. So why did you make that investment? Sometimes there will be situations where your question might impinge upon the privacy of somebody else. So if you, for example, ask, who are the other beneficiaries? You might not get the answer to that, because that would be that might damage somebody else's rights or somebody's interest. But basically what you have is you have what I would call supervisory powers. You have the ability to keep an eye on the trustee, to see what the trustees are doing, to make sure that they're following the rules, and to ask questions if you want to. Actually, truth is, most beneficiaries don't bother, because they understand that they don't have anything yet, and they are patient. But if you have these powers and you're interested, then by all means you can use them. So we continue. You have the power, you know. You know that there is money. You know that you are a beneficiary. So you have the power to demand that the trustees pay you money? No. You can ask for money. If it's a discretionary trust, you can ask for money. You can say, hey, I'm going to Oxford University and I'd like some help with my tuition fees. And the trustees might think about that, but you cannot demand money. The only time you can demand money is if it's a fixed trust and you have met all of the conditions. So in other words, if you are Doris and you are 25, then you are entitled. You have a fixed right to that money and you can demand it. But otherwise, absolutely not. Okay. Can you give instructions to the trustees? Again, no. You can give them suggestions. They might listen to you. But what we need to understand, and this is the most fundamental point for beneficiaries, and actually for trustees sometimes to understand, is that a trust is not a democracy. The trustee has an obligation under law to act always in the best interests of the beneficiaries. Sounds pretty good. But you have to remember that the best interest of the beneficiaries is not always what the beneficiaries think that their best interests are. So if I'm an 18-year-old, I might think that my best interest is to have a new Maserati. But the trustees may disagree with me. So I can ask them for money to buy a new Maserati, and if they don't think that's a good idea, then they're not going to give me the money, and that's as it should be. Because it is not a democracy. It is there to protect me, to help me to act in my best interest, and to do the things that the founder specified in the rules. But I don't call the shots, because until I get the money, until the distribution is actually made to me, it's not mine. Okay. One final point. I have these supervisory powers to watch, to check, to see what the trustees are doing. What happens if I don't like what they're doing? And the answer is, well, it depends. The trustees are not answerable to you. They act according to the rules, according to the law, according to the obligations of the trust instrument. And just because you don't like the decision that they made, that's not a reason to dispute their actions. However, if they are breaking the rules, if they are acting in a way that is unfair or dishonest, or they're not following the instructions or laws or obligations that are imposed on them, then you do have powers. You can, as a first port of call, go, of course, to the founder, if the founder is still alive, or you can go to the supervisor and see if the supervisor, protector, enforcer, if they will help you. If not, then you can go to court. But that's the last resort, and that's going to happen only in the situation where the trustees are behaving very badly indeed. Like I said, just because you don't like it is not a reason for you to be able to complain. But if they are doing something wrong, then yes, you can. That's all from this module. Thank you very much for your attention. Thanks a lot for watching. I hope you found that useful and helpful. If you'd like to see more of this, please like the video and please subscribe using the button that you can see just there. Thank you very much. Have a great day, and thanks again for watching.